Namaste. In this video, I will be explaining about the ordinance making power of the President. Introduction. Ordinance is a law made by the executive. The power to promulgate ordinance has been vested in the President under Article 123 of the Indian Constitution. The President has to exercise this power, as all other powers, on the advice of his Council of Ministers. To understand the meaning of promulgate in this context, it means to officially make new laws. Moving ahead, the executive has been vested with some law-making power to meet extraordinary situations demanding immediate enactment of laws. Main body. Article 123. Under Article 123, the President can promulgate an ordinance when both the House of Parliament are not in session. Here, both the House of Parliament refers to Lok Sabha and Rajya Sabha. And he is satisfied that circumstances exceed which necessitate immediate legislative action. So basically, when the Parliament is not in session, and if there is a need to make a new law, then the President can exercise this power under Article 123 of the Indian Constitution. Thus, an ordinance promulgated when both the House of Parliament are in session is void. It may, however, be made when only one House is in session. This is because a law can be made by both the Houses, not by one House alone, and thus meeting a situation calling for immediate legislation, which is the objective of Article 123, becomes impossible. Once promulgated, the ordinance has to be laid before each House of the Parliament when it reconvenes after making of the ordinance. Here it basically means that once the Parliament is in session, the ordinance needs approval of the Houses. The ordinance will cease to operate at the expiry of 6 weeks from the Assembly of Parliament. When the two houses assemble on different dates, the period of 6 weeks is to be counted from the latter of two dates. As under Article 85, 6 months can't intervene between two sessions of the Parliament, and the ordinance shall cease to operate at the expiry of 6 weeks from the Assembly of Parliament. The maximum duration for which an ordinance may last is 7.5 months. An ordinance may cease to have effect even earlier than 6 weeks if both the House of Parliament pass a resolution to that effect. It may be withdrawn by the executive at any time. If the executive wants to continue the provisions made through the ordinance, even after it ceases to operate, it has to get Parliament to pass a law incorporating those provisions. Ordinance making power is coextensive with the legislative power of Parliament. The ordinance making power of the President is the same as the legislative power of the Parliament. This simply means that the both ordinance making power of the President and the legislative power of the Parliament is same. Thus, the executive can, through ordinances, make only those provisions which the Parliament is competent to enact, except appropriation from Consolidated Fund of India. Here, when we say except appropriation from Consolidated Fund of India, is the executive has no power to make or to take funds from the Consolidated Fund of India. Only the legislature can do it. Thus, an ordinance can be made with respect to a matter in List 1 or List 3 and in List 2 when proclamation of emergency is in operation. Further, an ordinance like a law made by the Parliament shall be subject to fundamental rights. two case laws to the ordinance making power of the President. The first case law is A.K. Roy versus Union of India. In this case, the Supreme Court has emphasized that an ordinance is a law and is a product of exercise of legislative power. The second case is T. Venkata Reddy versus State of Andhra Pradesh. The Supreme Court in this case held that the ordinance making power in Article 123 is of legislative character. Conclusion. It can be understood that the ordinance making power has been given to deal with unforeseen or urgent powers and is subject to proper parliamentary powers. However, a government enjoying majority support may abuse this power. Thank you. Namaste.